Alexis and Eric Thiebel failed to appear today, even though it appears they were noticed to do so. Actually, it's a default judgment, so they didn't answer, which means you win today, but you still have to prove the measure of damages. Do you understand that?
I understand that. Or no?
All right, let me see here real quick. So this is also a landlord-tenant issue.
Yes, it is.
So in this case, you're indicating that you did receive a move-out form. So are you asking for your deposit back? Is that what your situation is?
Yeah, I received a mobile form, right? I received like a collection notice for some $5,900. Then I asked, and they say, "Oh, this is going to be applied to your deposit, right?" So I went to the system and I checked what they are trying to charge, right?
Well,
And
let's
most of
start
it,
with how much was the deposit?
$5,500.
5,500. You receive a
Nothing.
notification for what?
I didn't receive any notification. I went to the system and I checked that okay, yeah, I received a notification for a charge of $5,900
And what was
in
that
my,
$5,900 for?
they were charging paint of the house, cleaning of the house, and it says general maintenance.
Okay, when did you receive this? First of all, when did you move out and when did you receive this?
I move out. I live in the house 22 months. I move in on May 23 and move out in February 25. I pay $144,000 in rent and never miss one payment, never one payment late. And I got this notice on February 25th.
So February 25th, you moved out, and on the same day is when
I move out the 19. I move out the 19th of the 18th of February. I get this notification on the 21st of February.
so 19 you move out, on the 21st you receive a notification which is what they're
Uh,
charging you.
It says, it's only said this notification, it says you have a past balance due of $5,925.
All right, so let me see.
I can share my screen.
They never answered, right?
No, no,
So do you have a copy of that notice that they sent you?
uh, I have a copy. Yeah, I have it here in the email. I can share with you and I can send it through.
Yes, Mary, if you can allow them to share a screen, please.
Alrighty. Okay, I give you that permission, Mr.
Thank you.
Godinez.
So I got this email from the property manager company. It was on the 21st of February, and I was surprised, like, of what happened, right? I
Is
left
this an
the
apartment
house.
complex or is this a house?
No,
What is
it's a house. It's a house. Yes.
It's a house. Okay. So they just say that this is what you're owed is 59.25 is you owe this amount.
Yeah.
And that's
So I
it?
got
You didn't
scared.
receive what it was?
No, until I send this email to the
Uh-huh.
property manager asking what's going on with this, right?
Right.
And that this is February 21st. And this is like the details, and they answer me
So
here.
go back to the so this is the notification you received right here.
I went to the system and I saw this and I sent them another email, like what's going on?
Okay, so
Why
you saw
is
this
this
on the
charges?
21st then.
Yes, like what is this charge of cleaning fee, paint, general
Uh-huh.
maintenance? Like, and I sent him another email and he answered the property manager. And he said, there were several bills related to your departure: irrigation, deep cleaning, maintenance, and paint, right? For me, I was surprised when I got this and something was not adding because the landlord asked me for the house, right, in December or October, right?
Uh-huh.
So I went to realtor.com, as you can see here, and the house was posted for sale on February 19th of 25.
The day you moved out.
No, I just checked my records and I moved out on January 27th, but that's the day, like, I give the house before, but that's the day the lease end, and I paid that month fully, but I
So
moved
when
on.
did you leave?
I leave the house on January 27th. I found the video when I left
Okay,
the house
January 27, you left the house. When did you turn in the key?
that day.
That day. So January 27th, you turned in the key. And then you
Mhm.
received this notification on what day?
On February 21st,
February 21st. And it was January 21st.
27th. Yeah, this notification was in February 21st, almost 1 month after.
So it was 29 days or almost 30 days. Okay.
Yes.
All right. So you see this notification, you ask them about it. They say that they have these fees and
Mm-hmm. These have these paints and maintenance. And I went online and I checked on realtor.com and I found out that they listed the house on February 19th, right? I was surprised why they were charging me with paint and maintenance if when I got the house, it was full of stains and I have proof and I fill out an inventory and I return this inventory
okay.
with
I don't
all
need
the
to go.
pictures.
I don't need to go to that point anymore. All I need to see now is at this point, they didn't answer. Okay. So you could stop sharing your screen.
Yeah, the property manager said or answered me that this was instruction of the owner and he cannot do anything. Like
Yeah, no,
and
that's okay. I don't need any more information on that. I just want to look to see here. Are you suing then for 5,200 or 50? No, you were paying 5,200 in rent. You're asking for 5,500 back. Is that correct?
plus damages, yes, please.
What are the damages?
I've spent around $5,000 between time, attorney's fees, interest of that money. I needed to get lended that money with credit cards, and they are totally bad faith with this. Like
So what attorney's fees did you pay? Because you don't have an attorney here today.
I don't have it here because but they if you see the demand letter, they send this demand letter. I pay $900 in attorney's fees.
To who did you pay $900 to?
Frank Orozco, it's my lawyer. If you see the letter,
Okay.
I
And
sent to
so
them.
is the lawyer the one who prepared the petition for you?
Yeah, and the demand letter. Yes, I didn't
And
understand the
then you
process.
just filed it. Is that correct?
Yeah, that's it. I went 3 times or 4 times to the because I didn't understand the process. So at the end, I end up hiring an attorney because it was very difficult for me. And then I needed the deposit to move to another house. I was counting on it. I put this money in credit card.
Well, I get that you had, to another deposit, but that's not, you were going to move anyways, regardless. So that was, you moved prior to this happening. Because there's no guarantee that you were going to receive that before the 30 days and you had already moved in January, right?
Yeah, but I was expecting to pay 1 month interest, not I don't know how many months now, like 7.
Well,
Like,
I get that, but still, those are
mhm.
personal financial choices that are made. I'm not going to grant you interest on a deposit that you paid that you had to pay no matter what. Okay. I have no way to understand or believe or to know that you wouldn't have taken time still to make that deposit, and make payments over time. So that's not sufficient evidence here. But I will grant you the $900 in attorney's fees. I will grant you the $5,500 in the rent amount. Sorry, not the rent amount, the deposit.
Deposit, yes.
I don't find that there's bad faith here because they did in fact send you a notification. You did show what they delineated on what their amounts were for. However, they needed to be here to substantiate because clearly the $3,000 for painting a house is not something that you would have been responsible for because that's regular wear and tear. And so
Yeah, and the
that means that
maintenance.
the other issues probably are the same. So I'll grant you the full deposit amount of 5,500 plus 900 in attorney's fees. Okay?
Thank you, Your Honor. I have another question.
Yes,
Like,
sir.
she is a real estate broker licensed in the state of Texas. She always knew this was wear and tear. Like, and she didn't answer any of my communications. Is that not bad faith? Like,
No.
she sold the house 1 month ago, and she just ignored everything. She just kept this, and
That just
found
means
out
she's a bad
myself.
person. It doesn't mean it's bad faith. Bad faith, the definition is that they're going out of their way to treat you in a manner that is fraudulent or something like that. She ignored your calls. That's not bad faith. That's just not being a good person, right? That's what that.
Using my deposit to paint the house, to sell it, to get a profit, it's not bad faith.
Well, you have to prove that that's what they did.
But
And
I have the
not,
receipt of the full
but
paint, and I have the pictures
that's
of the
not
house.
the, sir, that's
Uh-huh.
not the definition of bad faith under this case where you're trying to get a deposit back. Okay, that doesn't apply. If you want to, include something else in terms of what the lawsuit, you have to bring evidence of that. Okay.
I agree. Like what I don't understand is like I got all the images and pictures and the inventory of how I got the house. I returned this house in a better position. I stay
I
in the
don't doubt.
house without free 3 months. I'm trying to
I
be
don't
a good.
doubt for a moment that you turned in the property better than what you received it. I don't doubt it. But
But
that has nothing to do with you getting more money
so
and entitle you
like
to more.
no, I understand. Like so like I don't know. This person just can be like I don't understand like how the law stop this person to continue doing these things,
The
right?
law is meant to put you back in the same position that you were in before this happened. Before this happened, you were entitled to your deposit of $5,500, right?
Okay.
You had to go out of your way to spend money to hire an attorney. Okay. Now,
Mm-hmm.
typically, if the attorney's not here, generally, I'm not going to grant attorney's fees if they're not actually here with you. But I'm granting them because I can see that an attorney didn't
Okay.
prepare the petition. I don't see the demand letter, but I don't doubt that it was sent that the attorney sent that for you.
Yeah. It's a certified email.
Okay, but like I said, I don't see it here, but it doesn't mean it didn't happen. So I believe you, but I'm not going to on top of that grant you, you know, interest because you had to put another deposit on your credit card, which you were going to have to do no matter what, right? There's no evidence to suggest that you would have paid it right away and not incurred any interest fees. There's just no
Okay.
evidence of that. Okay. You can
Okay.
say you would have done it, but that's just not sufficient. Okay.
Okay.
So for me to put you back in the position that you were in prior to this happening, I'm giving you the $900 in attorney's fees. I'm giving you your deposit back, the full amount, even though they did in fact list what they claim they had to do. Some of it may have been valid. I don't know, but they're not here to defend it. So they don't win on that. You do.
Thank you,
Okay.
Your Honor.
I'm not going to grant you money just because she was a jerk.
Yeah, like for me, it's not about the money for myself. I already spent this money. For me, it's about, and this is maybe just personal sharing. Like I see people, for me, that it's abusive, and she know, and we send emails and we send letters, and she just ignore everything. And the property manager like, dude, it's her instruction. I cannot do anything. But like
And
she did
maybe
this to sell the house, like, and
Maybe,
she will
sir,
continue this.
maybe it is abusive, but the law doesn't provide for a judgment in your favor just because they were abusive in that way.
No,
Okay.
yeah, that's why I asked about what it was the definition of bad faith, like,
Well, in this
and
case, bad faith is they didn't give you the notification within 30 days with the itemized um, listing of what it is that they were retaining the deposit for. That's what the bad faith is. That's how it's
okay,
defined in the
okay,
property code.
well, okay.
All
Thanks,
right.
Your Honor. I
Okay.
understand.
Thank you, sir. Good luck to you. We will
Thank you.
send
Good
you a
luck.
copy of it here later today.
Thank you. I appreciate it. Bye.
He's not here now. What that means is that for plaintiffs, you win your case today, but you still have to prove the measure of damages, all right? This is relatively simple to do. I don't need all the fluff. I don't need all the background behind it. I just need to know why it is that you're suing. Did you give him money? I've read the complaint. You gave him a check for 10,000, then he wanted it issued in his personal name and then never performed the services. So I basically need to hear that, the nature of the check that he cashed it, those kinds of things, and then we can go from there. Okay. All right. So if one person wants to speak on behalf, you can go ahead and start.
Yes, this is Tawana Fondren. I did bring on Friday, a folder with pertinent information and, the lady, Mary, she scanned everything in, but this is the canceled check. We've known Joshua since he and my daughter were in school from 3rd grade through 12th grade. We know his mother and I are longtime friends. So, and he works for, or president, was supposedly president for Fortis Roofing. And we hired him to complete an addition for our home where my mother, we planned for her to move into it. And so this is the canceled check for $10,000, which he, I don't know if you can see that.
So he in fact cashed the check, but he didn't do any of the work.
He cashed the check and didn't do the work, and in the folder, and it should be again, scanned in is the text exchange where he basically, put me off for a couple of weeks and made promises that were kept, and
All right.
no good faith effort to follow through whatsoever.
All right. So you're suing for the 10,000. Is there anything else?
I think it was 600 just for damages, for that was very stressful. This was a longtime friend, and yeah, it's just, it was stressful for my children and myself.
All right. I'm not going to grant the $600, but I will grant judgment in the amount of the 10,000 for the amount of the agreement that you had and the amount that you paid him, and then for the work that he never completed. So the judgment will be in the amount of $10,000. Okay?
Okay, and may I ask a question, please?
Yes.
How do we follow through with this? How do we?
So I can't give you advice on the case, right? But he does have time to appeal this decision, right? The reason that he would appeal is because he didn't receive proper notice of this hearing. Today in particular, there was an error, right? And so it's possible that he could file an appeal, or file a motion for a new trial because of that. Under those circumstances, it's likely that it would be granted, okay? Most likely the motion for a new trial because he didn't get proper notice. So that's a possibility, but he has, in essence, 21 days to do that. If he does not, then after that point in time, you can then secure your judgment with the county, and then you can go and try and collect it from him. Again, I can't give you advice how you go about doing it.
Okay.
But
So 21 days, that's what I was most
right.
interested in.
Yeah, you'd have to wait to give him that time to at least appeal or request for a new trial. He has less than that to do that, but
Okay, thank you. And one more question, please.
certainly.
After the 21 days, will the judgment be mailed, or do I need to come by and pick it up, or how's
Talking
that?
about the judgment, or
What you're saying that if he doesn't appeal within 21 days, then I assume what you're saying is that your judgment today will stick, and he owes.
that's correct. So we will send you that judgment right away. In other words, Mary's going to prepare it. I'm going to sign it. We'll file it, file stamp it, and then and scan it into the system. You'll get that today. You still have to wait the 21 days before you can go out there and try and collect, because obviously, I mean, you can go ahead of time, try and collect beforehand, but it would be for nothing, because if he chose to either get a new trial or appeal it, he that's within his right under the procedural rules to be able to do that.
Correct. Okay, thank you very much.
Thank you.
Good luck to you.
Thank you. Have a good afternoon.
Thank you.
Thank you.